the court finds that with regard to that offense, the mitigating factors slightly outweigh the aggravating factors, and it is the judgment of the court that she be committed to the Department of Corrections for 5 years in that matter. With regard to count 2 as amended in the matter ending in 528, it is the judgment of the court that you be sentenced to a term of 12 years in the Department of Corrections. That is slightly greater than the presumptive term, and that sentence will run consecutively to your sentence in the manslaughter case.
And joining me now is attorney Logan Elia from the Rose Law Group. All right, your first reaction, 17 years total.
I think it's a wise decision. I mean, I think it's a splitting of the difference between what the defense wanted and what the prosecution wanted, and it balances the two competing interests. There's a very serious crime here that needs to be redressed, but it's committed by a youth with a lot of trouble, and our system is both about retribution but also rehabilitation, and I like to think that we can have hope that somebody at this age with those problems, may be able to set their life straight.
Right. You talk about the problems. Bianca talked about it as well. Again, I just want to bring up what the judge said, because that struck me, aside from obviously hearing from Preston Lord's parents, which was just gut-wrenching. And again, both sides here, there is no win, right? So the judge had said this: I've been at this for a long time. I don't know that I've ever seen anyone whose mental health problems are so profoundly affected by alcohol and drug abuse. Do whatever you can to do in custody to get yourself ready when you are released. You cannot drink. It is a miracle that you are alive. I mean, again, the judge almost sounded emotional. And the fact that, he said that he's been doing this for a long time, hasn't seen anyone go through this. I mean, just the gravity of it all.
I mean, I guess what I think is it shows that the defendant's in this position because of his drinking problem, right. But also I think he's receiving a slightly more lenient sentence because of his drinking problem. If he were just a cold, sober, evil person out to do murder, he would have received a longer sentence, and I think that's why the judge has given him less than the prosecution wanted, and it's good advice to him. Hopefully he doesn't continue down this path.
Okay, so the fact that Hines is the first of 7 members of the Gilbert Goons here charged with first-degree murder, he's the first and only one who changed his not guilty plea into an admission. How does this first case affect all the other cases? I mean, do you think that maybe perhaps there'll be a change in plea for the other cases because of what happened today?
I do, absolutely.
Why?
Well, first, the overwhelming majority of criminal cases do not go to trial. They resolve by plea bargaining. But the defense faces some problems as a result of this plea. They now have one of their friends and known associates pleading guilty to these crimes. That establishes that at least one of them was there doing this. So it's more difficult for the rest of them to maintain absolute innocence. And additionally, because of the guilty plea, he's no longer in jeopardy. So he doesn't have a Fifth Amendment right against self-incrimination because he's pled to the crime.
Right.
And he's not going to be charged again. So he can now be compelled to testify against his associates, and that is not good for the defense.
Right.
And then one more thing, I feel like I'm talking too much, but
no, okay.
It creates a baseline for the plea negotiations. The other defense counsel will look at this plea and say, okay, we should expect to do around this well, or at least this is the goal.
This
right?
is similar,
This is similar. We know that this is probably in the ballpark of what we could negotiate as well.
Right.
And that's really important information to have.
Yeah, possibly the best case scenario in their case. All right. Okay, I want to get to our second case here. Yui Inoue, she was just convicted. Again, this all happening within the last hour. She was just convicted of killing her 2 young kids nearly 4 years ago and sentenced to life in prison. Your reaction to that?
I'm not surprised at all.
Yeah.
She's a mother who murdered her 2 children. It's a terrible crime. Life in prison seems entirely appropriate and expected to me.
So this was interesting to me too. During her trial, apparently the defense raised issues about her mental state, including depression, her erratic behavior for the murders in the days leading up to it. The jurors apparently rejected any arguments for diminished responsibility. Explain exactly what that means and how that affected everything.
Well, let's come at it backwards. The jurors rejected it, so at this point it means nothing. It's the defense that failed. It just didn't work.
Right.
But I believe the aim was to say, I should not be fully culpable of murder. I should receive a lesser sentence because I'm not able to fully form the intent to commit the murder. And what we saw in the Preston Lord case just now is that there's a difference in intent between murder and manslaughter. So I think they were going for essentially the same thing, and it just didn't work.
Right. Okay, I want to get to our final case here, the Tesla arson case. Explain why this is going to be a federal case versus a state case, and just really the severity of it.
Sure. So vandalism is usually prosecuted at a state level, and terrorism is usually prosecuted at a federal level. There are very strong federal laws against terrorism, and not all vandalism is terrorism. And one primary way to distinguish them is that terrorism, at least in firebombing something without murdering anybody, it's a crime designed to influence political behavior or send a political message. And I believe that everyone believes the reason that the Tesla dealership was set on fire is that there's dissatisfaction with the political activity of Elon Musk.
Right.
And they want to send that message. And if you're burning things to try to influence government policy, that's a more serious crime than just doing something dumb.
Right. Okay, so I want to unpack that a little bit. So the fact that, you talk about the political component. If Elon Musk was not a part of, the Trump administration and being a part of the government, would this have been tried as a state case?
So I believe that it would, but I want to be careful with what I'm saying here.
Okay.
I don't want to diminish that the fact that Elon Musk has a direct line to the president and the president has a direct line to the DOJ, that's not unimportant.
Right.
But also, this crime only exists as terrorism because it's meant to send a political message about Elon Musk.
Okay.
So it wouldn't be, if Elon Musk weren't involved in government,
Right.
then burning Teslas probably wouldn't be prosecuted as terrorism. And likewise, burning another valuable piece of equipment, if they set on fire bulldozers, it's probably not terrorism, it's probably vandalism.
Okay, so what's interesting is the suspect in this case, 35-year-old Ian Moses. The defense is arguing that he should be released while waiting his trial because of his full-time job and that his family members are here to support him. Do you buy that?
I mean, defense attorneys have to argue what's available.
Yeah, but is that a strong enough argument?
No, that's a guaranteed loser.
Okay.
I mean, I can't make guarantees, but that's a guaranteed loser. That's not happening. That's how
not strong enough.
You stay out of pretrial detention for a DUI because you have a job, not a federal felony where you're looking at 5 to 20 years of imprisonment. And as an aside, I'd be kind of surprised if he does still have a job. This seems like something you might get fired for.
Yeah, okay. Also, he was recently diagnosed with autism. Does that have any weight?
Probably not. It's common practice when facing serious criminal charges to do a pretrial psychiatric evaluation
Right.
to see that you are competent to stand trial.
Right.
And so what I think is potentially the case here is that they did that pretrial evaluation. They did not receive a diagnosis that would render him incompetent to stand trial, but he did meet with medical psychological professionals, and they said, "Hey, we met with you. You have autism."
Right.
So I don't think that that's going to advantage the defense in any sense, though, here.
And again, that's probably not strong enough of an argument for him to allegedly did what he did.
No, I think that would be like the diminished capacity argument raised by the mother who killed her children. Depression is real, but it's not an excuse for murder. Autism is real, but it doesn't excuse firebombing Teslas.
Okay. All right, Logan, you've been excellent. We appreciate your time and your deep dive analysis. Thank you so much.
Thank you.